Yes, Aditya. So just introduce yourself.
Very good evening. My name is Aditya Gaur. I belong to Kutch district of Gujarat. I completed my schooling from Bhuj and thereafter pursued undergraduate from Gujarat National Law University, Gandhinagar. After my undergraduate, I also pursued a postgraduate master's in law with a specialization in constitutional and administrative law again from Gujarat. Since the year 2020, I have been practicing before the district and taluka courts of Gujarat. And in the year 2017, I started an initiative called Law Briefs, which was a website wherein I used to prepare case summaries of Supreme Court and High Court judgments in simple English so that it could be distributed with various people who are not from the legal background and they can they can understand judgments easily. I have also co-authored a book which is published by Thomson and Reuters. It is a book which is based on anti-corruption and vigilance law. And I have also a guest speaker at Rashtriya Raksha University, Gandhinagar, wherein I take training sessions for investigating officers and legal officers of Central Bureau of Investigation. And I am very much interested in legal research and legal writing.
Okay. Why you want to become a judge, Aditya?
There are two instances that have piqued my interest in becoming a judicial officer. The first is the reason, the power of the law that has always attracted me to pursue this field. Secondly, I believe I have been blessed enough to get various exposures, being in corporate, being in chambers, high court litigation. I've also been at a research position in National Judicial Academy, Bhopal. But in all of these experiences and all of this exposure, I have realized that my interest lies primarily in doing social services. If whatever I have been blessed with the relevant exposure, I want to use it for the people belonging to tier 2 and tier 3 citizens. And I believe a position as a judge not only gives me this opportunity to understand and also do justice for the people belonging to taluka and districts, but it also gives a better career opportunity from what is available as belonging to my interests. So that's
okay. What qualities you have which judge required?
I believe the essential qualities that a judicial officer requires is that of understanding cases and doing the real discovery from what is placed before him. Reading files, understanding judgments, and interpreting law in a rightful manner. So I believe my relevant exposure in reading judgments from the past 5 years, analyzing them, preparing case summaries gives me an edge to be a better judge and also to understand factual scenarios before me more precisely and to give relevant judgments based on the decisions of the honorable courts.
Okay. So you are from Kutch. Can you tell us anything famous from in Kutch, or what is the culture in Kutch?
Yes. In terms of tourism, Kutch is very much famous for Run of Kutch. There is Mandvi Beach, also located 60 kilometers from this particular Run of Kutch. So it is a combination of beach and desert. More particularly in terms of tourism, Bhuj is also famous for Aina Mahal. Mandvi, a town in Kutch, is also famous for one of its more prestigious rural mahal. And in terms of foods, I believe Kutch Dabeli is popular not only in the terms of national but also at international levels, wherein I have seen many entrepreneurs from Kutch going to international cities and doing business of dabeli there.
And wonderful, Aditya, wonderful. Now tell me something. I mean, you've done your post-graduation in administrative law and constitutional law. Tell me something about the doctrine of legitimate expectation.
Sir, can I take a minute to?
Yeah, sure.
Sir, pardon me if I am wrong over this, but I believe the doctrine of legitimate expectation talks about the rule of interpretation. As in,
is it as a rule of interpretation?
Sir, I may be wrong over this. So I believe, sir, I am not well equipped to answer this question.
Is it different from estoppel?
Yes, sir. I certainly believe it is different from estoppel.
Okay, let me give you an illustration. If a representative of the people makes a representation in the upcoming elections, will it raise a legitimate expectation or not?
Sir, representative of a people?
When the representative of the people makes a representation to the people about a promise, in upcoming elections, will it raise a legitimate expectation or not?
I believe it will raise.
You believe it will be? Are you sure about it?
Yes, sir.
What about the Wednesbury principles?
My apologies. I have to read more on it, sir.
Okay, so your second subject was constitutional law.
Yes, sir. Constitutional.
Constitutional law. All right. I mean, how is the Constitution of India different from the American Constitution? Can you tell me 2 points?
Sir, I believe the first point would be that it is more of a quasi-federal in nature as compared to primarily federal in character, which is US Constitution. The second point of differentiation that I can raise is that in fact of the enforceability of fundamental rights, which is more profound than the doctrine of basic structure, which can be found in the Indian Constitution as compared to US Constitution.
Contextualize the particular comparative analysis with respect to freedom of speech and expression.
The term freedom of speech and expression, which has been guaranteed by virtue of Article 19, subclause 1, subclause A, in Indian Constitution, has covered under it various aspects. The famous case of Sakal Newspapers Private Limited versus Union of India of the year 1971 by the Honorable Supreme Court has also incorporated freedom of press into this particular freedom of speech and expression. The freedom of speech and expression.
How it is different from our? My question was how our freedom of speech and expression is different from the American speech of freedom of speech and expression, American idea.
Sir, I am not aware of the American idea of freedom of speech.
So you have not done a comparative study in your LLM constitutional law?
Sir, my area of topic was media ownership, and I was focused on.
What, sorry, can you repeat that again?
So media ownership in terms of Article 19.
Media ownership in terms of Article 19.
Yes, sir.
Okay, Aditya, like the cases which are very, high profile cases जो हमारे इंडिया में हो जाते हैं और मीडिया उस पर जो है अपनी चर्चा करना शुरू कर देती है एंड somehow the media कई बार अपना जजमेंट भी काइंड ऑफ सुना देती कि ये गलत है और ये सही है और ये इस डायरेक्शन में होना चाहिए. सो हाउ यू फील लाइक ये चीज रोकनी चाहिए हमको या फिर होने देना चाहिए, ये सही है या गलत है?
I believe the honorable courts and the judges of the honorable courts have been repeatedly passing statements against this type of media trial. And I am also of the firm opinion that there should be certain regulations on which the media should report its half-baked truths before the society, because media, being the fourth pillar of democracy, plays a very crucial role in dissenting information to a large number of public. And majorly, we can see that in many of the instances in the past, the media has not depicted the right picture before the citizens and has done the its job of dissenting rightful information. I believe not only there should be a regulation on media and media should be stopped from dissenting information that is not completely true, but I also believe that citizens also have a right to fair knowledge by virtue of Article 21. And if media is not dissenting rightful information, then it also infringes this particular right of the citizens.
What
so
has the Honorable Supreme Court said about this entire matter in Reliance Petrochemicals?
My apologies, sir. I have to read more on this particular case, sir. Reliance.
All right.
Aditya, there is a like if anything happened to someone, it is like people do reluctant to go to police station to lodge their FIR or do file their complaint or something. Even people reluctant to go to court because they feel that it kills their time. If you becomes a judge, and being a judge, how you can motivate a society that the court procedure will not kill their time, or any provision which are already enacted in the law जो हमारा time save करती है, or you can suggest those people not to worry about it and you just come and seek your remedy.
Being a judicial officer, I will be guided by the principles laid down by the Honorable Apex Court in Husainara Khatun versus Home Secretary Bihar 1954 judgment, wherein the principles of speedy trial were laid down. And I would also try to ensure that the principle of justice delay and justice denied is not becomes a cause for them. As far as provisions are concerned, I believe both Code of Criminal Procedure and Code of Civil Procedure provide adequate remedies to ensure that the remedies which the litigants seek are not prolonged and the tactics that are being adopted by the parties to delay a particular trial are not being adopted. I believe the reference to Limitation Act and the principle behind the reason the Limitation Act was enacted also plays a very crucial role in this. As far as specific provisions are concerned, I believe the Code of Civil Procedure provides for adjournments and 3 maximum adjournments that can be laid down under Rule 17 of the order. My apologies, I'm not able to recall the exact order. 3 adjournments that are being permitted in a particular case. And also the Code of Criminal Procedure provides for various remedies to the litigant in terms of cost that can be imposed on the parties who is trying to derail the litigation and who is trying to derail the particular trial before the court.
But still we have the very much pending cases and the justice is till now justice is delayed. Very few people get the justice at right time. Why so?
I believe there are multiple factors which play a role in it. It also becomes of the fact that many times the parties want to agree for a settlement or the lawyers. One of the factors which I can think of is that many times parties go for settlement but do not come to a particular specific settlement, and then they again join the trial for litigation. And
So
I
if
think
the party does not come to the on the hearing, what is the provision we have in the civil proceedings?
the Order 9 and Order 9 talks about it, which states that we can proceed either ex parte and we can proceed ex parte against him and go for the decree against him.
Okay, if the ex parte order, if ex parte proceeding has been ordered and the decree is passed, do we have any provision to set aside it or to go to the appeal?
Yes, I believe there are 3 remedies against it. The first remedy is to set aside an ex parte decree under Order 9, Rule 13. The grounds for setting aside are that summons was not duly received, and even if the summons was received, he was precluded from appearing for sufficient cause. The second remedy is to file an appeal under Section 96, and the third remedy is to file a revision before the very same court. And these 3 remedies can be approached by the particular.
If the appeal has been filed but that appeal is dismissed, can we file application in Order 9 Rule 13?
Yes, both of the remedies are stand on distant footing, and once the appeal.
I'm repeating question. If the appeal is filed against the ex parte decree just to set aside it, and the appeal is dismissed, now can we file application under Order 9 Rule 13 to set aside the this ex parte decree?
My apologies. I want to correct my stand. Once the appeal is dismissed, then there is no further remedy available under Order 9 Rule 13.
Okay.
Aditya, you are from Gujarat and you have done your LLM in administrative law. Can you tell me something about the landmark judgment from Gujarat, Govind Chhaganlal Patel versus APM committee with respect to administrative law?
Sir, my apologies. I am not aware of this particular.
All right.
Okay. Okay, what is the civil proceedings? How the civil proceeding initiate? Let's suppose the suit value is 1,50,000 rupees. Okay. So what is the procedure to initiate the civil proceedings?
The civil proceedings are instituted on a basis of plaint, and the plaint should contain the specific amount of claim, the amount of stamp duty, and the various rules laid down under Order 3 of the Civil Procedure Code. And once the plaint is instituted, then the court issues a summons notice to the defendants, and then defendants is required to appear before the court and do his pleadings, which are guided by Order 6.
Okay.
What is delegatus non-potest delegata?
The principle of delegatus non-potest delegata refers to the term that the delegatee cannot further delegate, which essentially means that if the certain powers are bestowed on a particular authority, then they have to perform this particular duty, and they cannot further delegate this particular duty.
Why? Why they cannot further delegate? What is the logic behind this particular principle?
Sir, I believe the essential logic is that if the authority is vested on a particular if a duty is vested on a particular authority, then that duty does not itself give power to further delegate. And the basic logic behind it is that to ensure that the authority performs its duty and does not just keep delegating it further, and the non-performance becomes difficult.
Okay. What is the difference between rejection, return, and dismissal order in CPC?
The term rejection in under CPC means the plaint is rejected at the outright. The term dismissal is that the company's rejection, return of a plaint. The return of a plaint is guided by Order 6 Rule 17, which states that if criteria is mentioned therein do not satisfy, for example, if the plaint is not filed in duplicate, if it is not valued properly, then on basis of it, the plaint can be returned. And dismissal of a plaint is that on being satisfied that the conditions of the plaint are satisfactorily fulfilled, but even though there arises no cause of action to proceed against the defendant, then I believe it is a dismissal of a plaint.
Dismissal is only of one type, which you told me that is done on the basis of the merits of the case, or we have any other provision also where the suit get dismissed?
The suit can also be dismissed for non-appearance of the plaintiff. Apart from
what remedies we have, not remedies, what options we have once the order is the suit is dismissed under order 9?
The remedy is to appear before the very same court and show the grounds for non-appearance, and if there are sufficient grounds, the sufficient cause in the opinion of the court that precluded the plaintiff for appearing, then the said order can be set aside.
Can we file the fresh suit
Yes.
in all
Fresh.
cases?
I will have to read more.
Okay. Okay, what is the status of child marriage?
Child marriages are void, and
They are void. Can the minor wife claim maintenance under section 125 CRPC?
yes, the section 125 of the CRPC. Yes, the section 125 of the CRPC provides remedies to minor wives to claim maintenance from her.
But you just now you said that the minor wife status, marriage status is void. Void means the marriage is nothing in the eyes of law. Then how she can claim maintenance under 125 CRPC?
Correct. My apologies. I believe the minor child can claim from a father, but not from the husband.
Okay, let's suppose. Okay, let's suppose I have murdered someone. Okay, I have caused murder, and you are lawyer. Let's suppose I came to you and I told you that this is my so and so cases. I murdered some person. Please take my case. You said okay. I'll take that. Can you give my statements or whatever the information I have revealed you? Can you give all those statements as a evidence before the court against me?
No, they are the statements you made to me are protected by virtue of professional communications under Indian Evidence Act. Section 122 of the Act provides for this.
No, it's like section number. Anything, Garvit, sir, you?
Just a question. I mean, does the editor of a newspaper have a fundamental right of speech and expression or not?
Yes, he does.
Yes.
Yes.
And can you explain a bit about this?
Sir, I believe by virtue of Article 19, every citizen does have a fundamental right of speech and expression. And the editor of newspaper, though is a part of a media which is fourth pillar of the democracy, he certainly enjoys this.
If he is a part of a media company, is fundamental right provided to a juristic person which is not a natural person?
Sir, fundamental rights is only to a natural person, in my opinion. And the editor of this particular company enjoys this particular freedom.
But no fundamental right, according to you, then no fundamental right can be provided to the media company. And the editor is writing for the media company.
Yes, sir. So the media company being a juristic personality does not have a fundamental right. And
And
the
how
right,
come the editor would have a fundamental right?
sir, I believe every citizen who have in whatsoever trade, profession, or occupation he is in enjoys this particular fundamental right, because these rights are inviolable in nature. And
Is there something which the Supreme Court said on this particular matter?
so the only case that I am aware of is Sakal newspapers versus Sakal
What
newspapers.
about Bennett Coleman?
Yes, sir. That particular segment also talks about it.
Can you tell me, I mean, Bennett Coleman is associated with which particular newspaper?
The Times of India newspaper.
Okay, if you are the magistrate and the police report came to you, what options you have?
I have an option to either to take cognizance over it, or to also direct further investigation on a particular case. And if it is a non-cognizable complaint, then I have a non-cognizable offense, then I can also treat it as an offense, as a complaint.
Under what section you will order investigation?
The further, I believe, further investigation can be ordered under 156 subclause 3 till the trial is commenced.
Till the trial commences. Okay, so you order this investigation before taking cognizance or after taking cognizance?
This investigation can also be ordered post cognizance, but before the trial gets commenced.
Okay, but where we have the provision related to further investigation?
Section 173 subclause 8 provides for further investigation to police officers, and 156 subclause 3 provides for further investigation to magistrate.
Is there any case on it?
I am not able to recall it, but there is a case. Yes, I have read the case on it. I have to read.
Okay, how we get to know that any particular offense is cognizable or non-cognizable offense?
Based on the schedule 1, which is provided in the code of criminal procedure code.
Okay, if what is the competency of judicial magistrate first class to try the case?
For offenses punishable up to 3 years.
Okay. So the magistrate competency to punish is 3 years. Can he try the case which is punishable beyond 3 years punishment?
Yes, both of the powers are distinct, and the power to try a case is different from power to punish. And therefore, a magistrate can definitely try a case which is punishable or extendable beyond 3 years.
So how do you identify that the particular magistrate can try the case or cannot try the case?
Based on the schedule which is provided in the code of criminal procedure.
Okay. So, okay, this is going to be our last question, Aditya. According to you, what improvement should be made in the legal field?
I believe the steps for improvement in the legal field post-COVID phase have increased tremendously. One of the major improvements I see is the incorporation of technology both at the subordinate courts level and apex court level. I believe digitalization of records could also play a greater role in further involvement of technology in the legal field. And secondly, I believe that I have personally, as in my practice, seen instances wherein summons are repeatedly issued on every date and the trial gets prolonged. So if there could be a particular cap being placed on the number of times a summons could be issued, and the number in which particular period the defendant has to place his presence, then I believe the prolonged trials could be cut short to a greater extent.
Okay. Good, Aditya. This is it. Okay.